I'd like to get started, please, if everybody would take their seats. For starters, I'd like to remind everybody that there is a question box here, and we really do welcome your questions. It will make for a much livelier question period than for me to, as moderator of the panel this afternoon, to sit there and ask all the questions that are on my mind that these people have to answer. If you also have questions, not only arising from the speakers, but as well arising from your day-to-day practice, then we would appreciate hearing from you. The next speaker is Reuben MacKnight. Reuben is counsel at Wilson Vukovich, where he practices tax law. Now, I don't know about you, but I took tax in law school. And if anybody wants to read my resume, I won the tax prize in law school. But yes, thank you. And what I remember about tax from law school, this is my little finger, and at the end of it there's even less space. But Reuben is going to bring us up to date on what we real estate lawyers need to know or need to at least think about when it comes to the Income Tax Act. Reuben.
Thanks, Ed. I did not win the real estate prize in law school. And in fact, in my entire career, I've done 2 house transactions, and they were incredible loss leaders. I was scared silly every step of the way. So, this is the opening remark. Most people think of tax, and as we've got on the screen here, I've got something my tax doctor calls narco-taxi. Within 20 seconds of hearing someone launch into an explanation of tax, my eyes become glassy, my body loses feeling, and I go into a shallow coma. But that's not what we're going to talk about today. Today, I want to talk about change. Now, until the middle of May, everybody in this room has an information advantage with your clients, because there have been a number of very significant changes in tax that won't have any bearing on your practice unless you act for landlords, tenants, or financial institutions. So if you don't act for any of those people in your normal practice, you can go into the shallow coma. If you do act for any of those people, pay attention for at least 20 minutes, because what I'd like to do is give you a heads up on some problem areas that are coming up, and until the middle of May, when all the accounting advisors to your clients wake up and get their heads out of T1 tax returns, we have an advantage in the information world because we can be proactive with our clients. So we've got 3 weeks to look like heroes to your clients. So that's the goal today. Tell you about the changes that are coming up and let you get an advantage. Now, this is what I want to talk about. You can put the paper away because I'm not planning to go anywhere near it. I'm going to cover it. We can't cover it all in 25 minutes, so I'm not going to even try. I want to talk about these areas. All of these issues arise out of recent cases, and most of you have probably heard of Neil Brooks, who's a tax law professor at Osgoode Hall Law School. In 2000, Neil prepared a paper for a conference on anti-avoidance in New Zealand, and the paper was entitled, "The Problem with Tax Law is the Judges." And I read this. Everybody knows Neil's bent. Neil's a good friend of mine, and I disagree with only about 85% of what he says. But I read his paper, and the first time I started, I got to about page 3 before I picked it up and threw it at the wall across the room. I was just so incensed and said, "Neil, you've gone too far this time." Okay, fast forward 3 years, we've had a string of decisions from the Supreme Court of Canada that are straight out of the bizarro world. There are a couple of cases, one case that real estate lawyers in particular will appreciate. There's a case called Will Care Paving, and the issue was whether if you go to an asphalt contractor and get them to lay an asphalt driveway, whether they are selling asphalt. And of course, you all know that they're not selling asphalt. The Supreme Court, in an incredible decision, came to the conclusion that of course you don't buy asphalt, it accretes to the land. And as a result, the tax credit was not available. So that was one of about 8 decisions of the Supreme Court in the last 4 years that have just turned the tax world upside down. So after we had Duha Printing and Willcare and Ludco, Singleton was okay because that was a lawyer refinancing his capital account. But there were a couple of other wacko cases. And I went back and read Neil's paper again and said, Neil, you've got a point. Now, the problem that we've got is that the Department of Finance doesn't feel constrained if they don't like the way the judges are acting. And so we are now faced with the prospect of legislative change to overturn some of these crazy decisions. And that's what's going to be the problem. That's what I want to talk about. First of all, I want to talk about interest deductibility, the shifting sands here. Simple question. Your client comes in and says, I have to borrow some money to use in my business activities, and I'm going to have to pay a third-party compensation for the use of their money. Now, question, is that compensation deductible in computing income? Anyone think yes? Couple of brave souls. Anyone think no? Okay, there are no justice lawyers in the room. Anybody think a definite maybe? Yeah. The group C wins. Because it's such a simple business question, and yet it's such a convoluted answer. And the simple answer is unless your client is borrowing money to pay for inventory or to pay for operating expenses when there's like a 99% chance it's deductible, under any other circumstances there are significant risks that it's not. And that is a bizarre state of affairs. Now, there are 2 reasons for that. One is a couple of judicial decisions, and the other is some legislative proposal. Now, the issue on participation payments, consider the situation where you're acting for a real estate developer. You go to a financial institution. Not surprisingly, the financial institution says, okay, we'll give you a loan, but if the project succeeds, we want a kicker. We want some upside. That's the participation feature. And the question is, when that kicker becomes payable, is it deductible? And there's a lot of controversy for many years. People thought, well, that seems like a reasonable business expense. It should be deductible in computing income. And it's not. Bad news, put bluntly, it's not deductible. And then finally we got a case called Sherway Center. And Sherway broke ground. We all thought, oh, this is wonderful. Maybe we can deduct participation payments, but unfortunately the Sherway case is very limited because what the evidence showed in that case is that the market rate was 11% and they borrowed at 9.5%, and the object of the equity kicker was to bring the overall return up to somewhere around 11%. And the evidence showed that really it was not a participation payment, it was just a form of deferred interest expense. And on that basis, they were allowed a deduction. Now, Revenue Canada, graciously, has said that they accept the Sherway decision, which is wonderful because very few people fall within that limited set of facts. The bigger problem in participation payments stems from yet another recent Supreme Court decision called Gifford, which came down about 3 weeks ago. And Gifford was a situation where an employee borrowed money to buy a customer list from a retiring coworker. And he tried to claim a deduction for the interest expense. And the whole issue was whether the interest was deductible as an operating expense or whether it was non-deductible. Originally, the issue was framed at, is interest expense a capital payment, in which case it's non-deductible, or could it be a deductible operating expense? The tax court, Don Bowman, went off on a flyer and explained why it could be deductible. The Supreme Court, in a rather convoluted decision, ignored all the issues that were framed and concluded that Interest is, quote, a payment on account of capital, which is the magic phrase in the prohibition section in the Income Tax Act. And if a payment is, quote, on account of capital, it is non-deductible unless you can fit within a specific exemption. Now, the problem that we've got with participation payments is that there are 3 conceivable slots you could put the payment into. It could be interest. Problem with participation payments, though, is that it does not accrue from day to day, it is not referable to a principal amount, and it is not generally considered to be compensation for the use of funds, the 3 classic tests of what is interest. So it doesn't fit that. There's a specific exemption for compound interest. It's not that. And then there's a specific allowance for financing expenses. Now, Sherway Center said that the participation payment was a financing expense if it wasn't interest. Finance didn't like that, so they amended the section dealing with financing expenses to expressly exclude participation payments. So double whammy. So if you've got a client who's got a participation payment, how do you set it up? And the issue is, don't anticipate that you'll be able to claim it as a deductible expense. You're going to have to go through some other steps. You will not be able to get the income into your client's hands and then give them a deduction to take it out. You're going to have to set up your legal relationship so that the income goes directly to the lender and never flows through your client, which means that you're going to have to either use some kind of a partnership vehicle or you're going to have to sell some kind of a revenue interest. It's explained in my paper how you might consider it. It's going to be very difficult, but as a result of both Sherway Center and now the Gifford case and another case that I'm going to talk about called Pantorama, it's scary if you've got a client that's got a participation payment. If your client is receiving the payment, it's simple, it's income. But if you've got a client who is paying the participation payment, be warned, you've got trouble brewing. The second one is the deferred or contingent interest. And again, there are a number of people who go into real estate developments and they say, okay, we'll only pay you interest to the extent we've got cash flow. Has anybody ever encountered that unusual set of affairs? The problem with that is that although the court and Revenue Canada may agree that the amount that you're paying is actually interest, you may not be paying it in the right year. So you get the absurd result that you've got an expense that should be deductible, but because you're paying it in the wrong year, it's not. It's just a bizarre state of affairs, but Revenue Canada is quite comfortable with that. Thank you very much. So that's the issue on how to deal with contingent interest. Now, there was a case called Hill, which deals with the development of downtown Regina. And Hill had a funny financing arrangement. We don't have time to explain it, but the case is cited in the materials, and that's an example of how to deal with deferred interest. So if you've got a client that is going into a lending arrangement that has a deferred portion of the payments, read Hill to see how to do it right. Otherwise, you're going to have a problem. Now, the other problems that I want to talk about from the Supreme's Ludco, this is a bizarre case. This is a situation where somebody borrowed money, they paid $9 million in interest expense, earned $600,000 in dividends, and the Supreme said, that's deductible. Nobody anticipated that result. And what happened there is the Supreme Court said that when you have an expectation of earning income, which is one of the tests for deducting interest, you don't have to earn net income, like income in excess of revenue. Gross income is sufficient. And that's a problem. That just opens the door for too much abuse. Not surprisingly, Finance and the Revenue Agency don't like that, and they've come back with some proposals. Singleton was the lawyer who refinanced his capital account, put a mortgage on his house, ran it through his capital account, ended up getting a business deduction for his mortgage interest expense. In a split decision, the court agreed that that was acceptable. My own speculation is that the people on the bench who did not like the decision were people who did not do that in their practice. Pure speculation on my part. But I'm sure many of the people in this room have done this little recapitalization finagle. And although the CRA doesn't like it, as long as you can trace the direct use from your mortgage into your business, it seems to be deductible. And then the last two cases are Stewart and Walls, and these deal with the concept of REOP, which is the reasonable expectation of profit. And we thought that Stewart killed REOP, but we thought that it was reasonably dead, but in fact it may be staying alive. And the problem with REOP is that, again, I'll put this squarely at the doors of the Supremes. The doctrine of REOP came from an unfortunate and unnecessary comment from Justice Dixon in an old case called Muldowan. And Muldowan was a hobby farm case, and the issue was whether the losses were personal expenses or whether they were expenses related to earning income. And it was clear that it was personal, but Justice Dixon went on and on in obiter, and CCRA, Revenue Canada as it then was, latched onto this doctrine of reasonable expectation of profit, and we've been haunted by it for 30 years. And we thought that in Stewart, it was finally killed. The Supreme Court in Stewart said that if there is no personal use and it's a clearly commercial use, then the REOP doctrine doesn't apply. So we thought that was good news. Revenue didn't like that, and they didn't like the decisions in the interest cases. So they came out with some proposals on October 31st. It was an interesting Halloween joke. And they were introduced as the reaction to the Supreme Court decision. They didn't expressly say it was a reaction to the Supreme Court because that would be in politic. But they said that the proposals were intended to restore continuity and to clarify the link between prospects for profits objectively determined. And they introduced two new concepts. One is called the reasonable expectation of cumulative profit, which doesn't break down into a nice acronym. And then we've got something called this profitability time period. Now, in the paper, I've got a very brief discussion of this for the simple reason I don't think there's a snowball's chance that these proposals are ever going to see the light of day. The reaction of the tax community? It's amazing what you can find on the internet. I think it's fair to say that the tax community and the business community universally rejected these proposals. Interestingly enough, they were introduced with much fanfare to deal with the issue of the deductibility of interest expense, which is usually the expense that creates the losses. And interestingly, the provisions never use the word interest. Go figure. Instead, the proposals are incredibly far-reaching. They catch all deductions that are related to income from business or property. They catch everything under the sun. They catch things that, when the professional community started to make submissions, Revenue sat back and said, oh, we never thought about that. You mean you can't deduct your interest on common shares? Oh, no, we didn't mean that. That's what it says in the legislation. It's perfectly clear. And the reaction from finance, interestingly, not from the Revenue Agency. The Revenue Agency, I don't think, approves of these proposals because they're just going to be impossible to administer. But the Department of Finance came up with these proposals, and they're absolutely inconsistent with accepted conventional wisdom and practice. So where does that leave us? Well, the Department of Finance can't live with the decision from the Supreme Court. They can't live with Ludco, and I think all tax practitioners agree. Ludco was a decision that just has too many, leaves too many loose ends and really opens the door for abuse with a gross income test. So something's going to happen. So what happens? These are my predictions. These predictions in a toonie. You'll buy you a cup of coffee downstairs. But we know that the government doesn't like this. We know that they're going to legislate a response because they can't win in the courts. They've showed us their opening bid, and it was ugly, but something's going to come back. So if you've got a client that's in the situation of Ludco, be happy until the end of this year. Party hard and take the rest of this year to figure out how to restructure your client's affairs because it's not going to be a party next year. Expect some kind of net income test for interest deductions and other deductions, not just interest, but soft costs and all the other expenses that normally go into a business venture. And look for an express exclusion of capital gains. For some reason, the Department of Finance thinks that that's not already caught. I think most practitioners think it already is. It's already dealt with in Section 9. You can't invest for a capital gain and get an interest deduction. It seems to be perfectly clear in the Act, but the Department of Finance seems to think they need more. Probably the new rules, whatever they are, will be effective for next year. The October 31 proposals were supposed to come into force in 2005. So notwithstanding that we won't have any idea what those new rules are going to be, probably until either just before Christmas or between Christmas and New Year's, which seems to be the Department of Finance timetable for drafting legislative changes to the Tax Act. It'll probably be effective next January, which means we've got 9 months to talk to our clients and restructure all those problematic business vehicles and all those ventures. So again, you've got 3 weeks to look like a hero. If you've got a client that's in this circumstance, give them a call and say, look, we've got a problem. There's an opportunity here for the balance of the year to fix this up, and let's get to work on this. So this is something that you can do that your clients will appreciate. Okay, recent cases of significance. I'm going to blitz through these. Case on deductibility of third-party fees that came out last week. You have to talk about Karr, mainly because it's good for the taxpayers these days. There's a case on rollover of real estate inventory, which is the absolute must-read for all real estate practitioners. If you only plan to read one tax case this year, this is the one to read. And assisting family members with startup. Quickly, Pantorama. This case came out last Wednesday. It's only available on the tax court site. And this is a case, if you're a tenant, you've got a problem. This is a scary decision with its implications. What happened here, Pantorama was a retail store, had leases in a lot of malls across the country, generally a 5 to 7 year term. The evidence was that they had 40 to 60 leases a year. They hired a third party called Snowcap to go out and negotiate with landlords, negotiate leases, renegotiate leases, solve problems, they basically outsourced all their landlord relation issues to this company. And they felt, under GAAP, that that was a perfectly natural recurring operating expense. Perfectly natural approach. The revenue agency said the deductions were, quote, on account of capital, because they related to the fundamental business asset of the company, which was its leases. And the tax court agreed, saying that the purpose of the expenditure was to expand the taxpayer's business and that there was an enduring benefit. Like the typical test for a capital expenditure is, does it create an asset of an enduring benefit? And the tax court said, well, you've got the exclusive use of this property for the term of the lease, so that's your enduring benefit. So they held that the expenses were not deductible. They were on account of capital, had to be added to the capital cost of the leases, and were depreciable over the 7-year term of the lease, which doesn't help you very much. Now, go back to Gifford, where the Supreme Court held that interest was, quote, on account of capital and was not deductible. That came out in March. And then you look at Pantorama, which gave an expansive view of what constitutes a capital expenditure. And now think of all the payments that arise in a real estate development business or in a retail operation, or if you're a lender, and start thinking about all the ways that people make payments for the use of property or for the occupation of property or for compensation for participating in a joint venture. And go back and ask yourself the question after Gifford and Pantorama, are any of those expenses on account of capital? And I'll bet the answer is most of them are under those tests, which means they're going to be non-deductible. So what do we do? Does this mean now that we have to look for specific deductions in Section 20? If you're caught under this express prohibition in 18(1)B, the only way out of that is if you can find an express exception in Section 20, and there aren't very many. We used to think you could deduct it under Section 9 on the basis that it was a business expense. But now if it's going to be on account of capital, we have to look for a specific deduction, and it's going to be tougher. So watch, this is going to be a cloud on the horizon. Okay, Karr. You can't talk about tax these days without talking about Karr. And the reason I wanted to raise it is it seems that the pendulum is swinging in favor of the taxpayer, but the real reason I want to talk about this is that there are 2 wonderful comments from the judges after haranguing them for the last 20 minutes. I want to give comment to a couple of tax court judges. Tax court judges are becoming very literary again. It seems that Justice Bowman is having a great effect on them, and it looks like we're finding new Lord Dennings when you read their decisions. And here's a classic example. There's a case called Canada Trust Co., which was a structured finance case where there was a claim for capital cost allowance and there wasn't any economic risk in it to the lessor. And the question was whether they were entitled to capital cost allowance claims, and Revenue Canada argued that the deduction was abusive. What the judge concluded was that effectively, after going through a long and extensive analysis of abuse and misuse of the provisions of the Act, he applied a judicial smell test, and it has this wonderful comment right at the end, says, although the facts tweak the nose upward, Karr did not apply. It's this wonderful phrase, bears repeating. There's another case that came out about 2 months ago called Imperial Oil, came out in the same week as Canada Trust Co. And this was an issue of large corporations tax. If you've got real estate developers, they may be affected by this tax as well. But what happened in this case is Imperial Oil bought short-term investments over a year end so that they didn't have amounts included in their taxable capital. And after a lot of analysis, the judge went through and said, look, this is a completely foreseeable transaction. It was apparent to anybody with half a brain that corporations with different year ends were going to participate in this kind of a transaction. Completely foreseeable. It was a commercial purpose. It was a bona fide transaction, and then concludes with the phrase, it was neither aggressive nor adventuresome. So you can have an aggressive transaction as long as it's not too smelly, you're okay. So there's opportunity yet. Okay, this is the must-read case. This is a decision from last year. It's about a year ago, called Loyens. And this was a transaction where real estate inventory was rolled through a partnership into a loss co and sold out, and the profit on the appreciated real estate was sheltered by corporate tax loss carry-forwards. And again, what happened here was that Revenue Canada challenged the taxpayer on Karr, and there is a wonderful analysis. The case is significant for two reasons. First of all, in something unusual for a tax court case, the judge explains how to do a transaction. Most decisions, they explain all the defects in a transaction. In this case, Judge Miller goes through at exhaustive length how to incorporate a partnership, and it's a wonderful decision for that. The second reason why it's important is that it talked about why Karr didn't apply, and in this case, they said that Karr may restrict loss trading, but it doesn't restrict profit trading. Now, in this case, the real estate was always inventory. It was transferred into an existing general partnership that had carried on business for several years before. They then transferred the partnership into an existing operating company that had valid loss carry forwards, and then it was sold out to the purchaser, and they triggered an income gain. And all of those are important facts. So if you were to try to create a new partnership, roll it into a recently created partnership, flip it into a company and sell it out, you probably wouldn't get that. And then the last thing I want to talk about is lending to family members. How many of you have a situation where your client comes in and says, my son or daughter is setting up business, I need to lend them some money, would you put a mortgage on my rental property so I can give them cash? And the issue here is when the son or daughter realize their destiny to be a statistic, i.e. a bankrupt. How do you get tax relief because you're not going to get your money back? Your client has made a loan to their son or daughter that they are not going to recover, and then they come around and say, can I get some relief through the tax system? And the answer is yes, conceivably, if you qualify for an allowable business investment loss, you can get a deduction. And there are two recent cases that are important. Rich came out last fall, and that dealt with the issue of when do you determine that the loan is bad. Father made a loan to son. Son's company went in the tank. Father wrote a letter to son saying, are you going to repay me? Son said, sorry, I can't. If you try collection, you'll force me into bankruptcy. Father logically said, well, I'm not getting anything out of this. Why should I throw good money after bad? Claimed a deduction. Revenue said, no, you've got to exercise your collection powers. The court said, no, you don't. Make a reasonable decision. You don't have to waste money if you don't think you're getting it back. Curtis was another classic case. This came down about a month ago, talking about here the parents mortgaged their rental property, lent it to their son, no paper, no discussion of what the terms of repayment were, and unfortunately they did not get the deduction. The moral of the story in Curtis is a little foresight and a little piece of paper gives you the tax deduction. Last thing, bottom line, pay attention. And in the paper, there's some issues about refinance properties that will probably scare you. There's some issues about replacement property rules, which is something that people forget about, which may solve some of your problems. And there are 2 cases on GST that I try to avoid, but you might want to just take a quick look at. And that's it. Thank you.
I've decided that for real estate lawyers, you ever pick up Scotch tape and you get it on your hand and then you try and take it off and it's on this hand and you keep going like this and it keeps sticking? That's environmental law. Because I find as a real estate lawyer, the more I try and pretend it isn't there or to shake it off my hand and say, I don't want to know about that, it keeps coming back at me. You didn't know that environmental law is Scotch tape. We have 2 speakers today, one you're going to hear now and one this afternoon, who are going to each bring, talk about 2 different aspects of environmental law. Rosalind Cooper is going to talk about what you do when your client has a contaminated property and what liabilities and obligations there are. Rosalind practices only environmental law. She is a partner at Faskins, and she's going to start us off. Rosalind.
Thanks very much. And you're a very lucky group indeed today because you do get 2 sessions on environmental law, not 1. And I think they thought it was too much of a good thing, so they decided to stagger us. Originally, we were back to back. But Donna will be speaking later on some other issues. What I'm going to talk about is really how you figure out if you're dealing with contaminated land, why you should be concerned if you're dealing with potentially contaminated land, and also some techniques to address these problems through agreements. And so the first thing I want to talk about, and it's really as background, is why should you be worried about environmental law or if the property is potentially contaminated? And there's a couple of different reasons for that. And I'm going to address this strictly from a real property perspective. First of all, there's potential liability through charges. Now, what I mean by that is that if there's some plume or some migration underway, the regulatory authorities may take the position that your client, as the owner of the property in the future, should be taking some action to stop that. And if they don't do that, that they're therefore liable to charges and prosecution. The other concern, of course, is what we call cleanup orders, which is that the ministry finds out that your client has a contaminated property, perhaps it's migrating off-site, and they issue some sort of an order saying, clean it up. And if it costs $10 million to clean it up, well, that's just what it costs. It doesn't matter what the value of the land is. The third concern is claims from adjacent property owners, which is if your client picks up a contaminated piece of property and it happens to be going off-site, they may be looking at third-party claims from adjacent property owners saying, you're contaminating my property and you're liable to clean it up. And then, of course, the fourth issue, which isn't so much as a liability, but it's still a property issue, is how does the fact that it's contaminated affect the impact or affect the actual value of the land itself? How is it going to affect the ability of your client to obtain financing if it has to with respect to the property? So you don't want your client to pick up a contaminated piece of property unless they're well aware of it and they've assessed the risks and taken appropriate precautions. So that's just some of the background why you'd want to know whether or not it's contaminated. Don't forget as well, because people often forget about this, that you need to be worried about contamination that's coming onto the property from an off-site source. And often I find when I talk to people about contamination, they're very focused on, is the property contaminated from an historical perspective? Is it going off-site? But they don't often focus on, is it perhaps coming onto the property as well from an adjacent property? And that's a very important issue. And I was recently involved with a real estate transaction where someone felt very comfortable about the land itself and its historical uses, but all of the surrounding uses were heavy industrial uses, and there was a real question as to whether they should go ahead without at least sampling at the boundaries of the property and ensuring that there isn't something coming onto the site, because that's going to have the same impact in terms of some of the liabilities and value of the property as well. So just keep that in mind. Now that you know about the liability associated with contaminated land, how do you find out if you're buying or financing property that is contaminated? And there's a number of things that you can do. And I think that anyone who advises a client to pick up a property without at least considering environmental issues could potentially be looking at a huge problem. And that's not to say that every property is contaminated, but I think you've got to at least consider the issue and turn your mind to what you might do to both do some due diligence and to protect your client in the event it is contaminated. And I think the comment about tape and the environmental area is probably quite accurate, because once you get involved with one of these properties and there is contamination, it's not that easy to just put it aside. So you really have to look at it beforehand. So what can you do? There's a number of things you can do from a due diligence perspective to assess if land's contaminated. And one of the most common that we refer to is carrying out some sort of environmental assessment. And there's something called a Phase 1 environmental site assessment, which is a reasonable method of carrying out some due diligence with respect to a property that won't cost your client a lot of money. Most consultants wouldn't want me to say this, but the average Phase 1 kind of runs $3,000 to $5,000. And what that will tell you as a Phase 1 is, what is the history of the property? It will involve a search of regulatory records that are in existence to find out whether there's any potential sources of contamination. The consultant will actually go out and do a site visit, and they'll look for potential sources of contamination, things like stressed vegetation or pipes sticking out of the ground, obvious signs of contamination. And they'll often also interview people at the site or historical owners to find out how the property was used in the past. And they'll look at adjacent land uses. And what they do at the end of the Phase 1 is actually prepare a report, which provides you with an assessment of what is the potential for contamination at this particular property. And it will also give you a recommendation as to whether or not you should go on and do further work. Now, everyone who gets one of these always hopes that the Phase 1 says, it looks fine, there's no potential problems, and don't go on and do any further work. And that's the ideal scenario. And if you get that, that's great. At least you've got some comfort. But sometimes they will say, we noticed some areas of stressed vegetation. We think you should do some sampling in this area. Or we noticed a couple of pipes sticking out of the ground. There could be some underground structures. Perhaps you should do some assessment in that area. And when you get those types of recommendations, you really need to follow up and assess whether or not you want to do further studies on that basis. That would take you into what we call a Phase 2 environmental site assessment, which is intrusive testing, where consultants are actually taking soil samples and groundwater samples and analyzing those to see whether contamination is present. But I think that you can't just simply take a Phase 1 that has recommendations that suggests that further investigation work needs to be done and ignore that. You've got to follow up on those issues and get some comfort level, because they really are warning flags about potential contamination. There are other things that you can do without necessarily involving a consultant, including, freedom of information searches and regulatory searches to get information on a property. And there's a service called Ecolog Eris that a lot of consultants use as well, but lawyers can use, whereby for really a few $100s, you can get a company to issue you a report which details information about a particular site. It'll look at historical databases, adjacent land uses, approvals that are in the ministry's hands, that type of thing. It doesn't give you 100% comfort in terms of the contamination issue, but it'll give you a flavor for what's been going on at the site for a relatively reasonable cost. But I think you really have to look into all of those things in order to give your clients some comfort on what they're dealing with in the property. So in terms of due diligence, that sort of gets you the information you need as to whether or not the site's actually contaminated or potentially contaminated. And then what do you do with that? And I want to talk a little bit about relying on reports. Because more and more these days, as people become more sophisticated, there are a lot of reports out there on properties. And often when I become involved with a transaction, it's not as though people are going out and generating reports for the first time. They already seem to exist. People have done them in the past. And I often get provided with reports that have been carried out by another party and asked, well, do we need to do more assessments? Do we need to do another one? Do we need to update this, or can we just rely on the one in existence? So I want to make some comments about reliance on previously existing reports and some cautions in that regard. First of all, check the date on the report that you get that you're looking at, because a lot can happen in a very short period of time. And depending on what the site is being used for, if you have a report that's 5 years old that talks about the potential for contamination, I wouldn't feel 100% comfortable relying on that report, because an awful lot can happen in 5 years, both from adjacent properties and from the property itself. So I tend to call that a dated report, and I think you want to be careful about when the report was issued. Also look at the scope of the report, because oftentimes consultants will be told exactly what to look at, and it's not what I call a full phase 1 or a full phase 2. They've been told to only concentrate on a particular area of concern. So if you're looking at that report, be aware of what the scope is and the fact that it may not be a complete assessment. So don't just review it and think, well, it says it's okay, so I don't need to worry. It may be a limited phase 1 or phase 2 report, so just be cautious about that. The other thing you have to look at is who the report was actually prepared for, because consultants have probably 2 or 3 pages of disclaimers at the end of all of these reports. And they disclaim a number of different areas, but one of the key things is they always say that they're prepared for the exclusive use of their client, and only their client. So, if you're acting for the purchaser and you pick up one of these reports that's been prepared for the current owner of the property, be aware that you're picking up environmental information, but you really have no basis upon which to rely on the report vis-a-vis the consultant. So if it turns out that the consultant was negligent and missed a whole area of contamination that they really should have picked up on, you're not necessarily going to have a right of action against that consultant with respect to that report. And there's a couple of techniques to try and get around that, and I'll talk to you about some of them. But I just want to flag that as an issue, because I often find that people will pick up these reports and say, well, I've got a report which says it's okay, and I'm going to rely on that report because it was fairly recent and it seems to be done by a reputable consultant, and that's not enough. You need to get what I call a reliance letter from the consultant, which specifically says that you may rely upon the contents of the report. If you don't get that form of reliance letter, then you really have no independent cause of action against the consultant that prepared it. And there's a case out there, and I won't get into detail on it just because of time constraints, but it's called CH2M Hill, which was a consulting firm in Ontario that had been retained by the government to carry out some assessment work and missed some significant contamination, which the court later held they really should have found. Now, in that case, you've got the ability to recoup against the consultant because it was a direct contractual relationship. But, if it had been in the context of a purchaser relying on a vendor's report, there could have been a significant problem in terms of recovery. So you want to be sure you get that form of reliance letter that entitles you to rely directly on the report. The other thing is a peer review of an existing report. That's another option if you're not 100% comfortable with an existing report, or if you think it's a bit dated, but maybe it should be updated a little bit. What you can do is get your own environmental consultant, ask them to do a peer review, and they're quite familiar with what that term means, of an existing report. And what they'll provide to you at the end of that is really a report which says that they reviewed the report prepared by consultant X, and based on the review, they have the following comments to make. And it's almost like a critique of the existing report of areas where they might have missed or concerns that may have arisen since that report was prepared. But it gives you some additional comfort from your own consultant that the assessment work was correctly done. So that's another option, which is not very expensive because it's really a desktop exercise where one consultant is critiquing another consultant's work. So keep that in mind as well. There's a case that I'll just mention about the reliance aspect that you can take a look at if you like, and it's called Wolverine Tube, and it's an older case, but that's the case that really set out the principle that you cannot necessarily rely on a report prepared for another client, and that's why I say that it's got to be directed towards you. So if you wanted to review some support for that proposition, Wolverine Tube is your case. In terms of consultants, and I think Donna's going to talk a little bit about picking a consultant and making sure that they're properly qualified, but I'll just flag that as an issue, and she'll talk about that a little bit later. But that's an important aspect as well. You do want to look at the consultant that's actually done the report to see how reputable they are, how familiar they are with a particular contaminant, and so on and so forth. The other thing that I should talk about is underground storage tanks, because I was told that that's a big concern for real estate lawyers and properties. So, underground storage tanks. There is specific legislation that deals with underground storage tanks. And it's not what most people think of, because they're always looking at the Environmental Protection Act and the Ontario Water Resources Act, which are the key environmental statutes. Previously, these provisions were found under the Energy Act and under the Gasoline Handling Code. That's all changed because now what we call the TSSA, Technical Standards and Safety Authority, governs and takes jurisdiction over tanks. So you'll find them in slightly different pieces of legislation than they were before, but many of the provisions are similar to what they were before. And what they essentially say is that if you've got an out-of-service storage tank, you have to remove that storage tank and you have to remove surrounding contaminated soil. And that's a legal obligation. And there's many times you'll find where your client is looking at a piece of property that has storage tanks on it. And it's extremely important to assess the potential liability. And it's not so much the tank. I find a lot of people tell me, well, what if there's an underground storage tank? It's going to cost me so much money to pull it out. It's not going to cost that much money to pull the tank itself. I mean, it tends to run around $5,000 to $7,000. The real cost is if it's been leaking. Because if that tank's been leaking and it's contaminated surrounding soil, cleaning up that surrounding soil and making sure that you clean it up in accordance with appropriate standards, that's going to be where your real expense comes in. So I caution you not to worry so much about the fact that you have to pull the tank, although that is an expense. It's more the fact that there could be contamination that's come out of that tank and how far that's gone and how extensive that is. You'll often see in agreements specific reps dealing with tanks. And people are often surprised about that. They say, well, with all the environmental concerns that a property could have, why is there specific provisions dealing with tanks? And the reason is because of the liability concern. Once one of these tanks happens to be leaking, you get huge potential for contamination, both of soil and groundwater, and potentially huge costs. So it's an important issue to be aware of, and if it's a problem, it should be dealt with specifically in the agreement. The other thing that you have to remember about tanks, and I'd refer you to a case called Tony's Broadloom on this particular issue, but generally speaking, there's a whole issue with environmental law about what a patent defect and latent defect is and how you can distinguish between the two. And in many cases with tanks, there are actually signals on the property itself that should alert you to the presence of a tank. Something obvious like a pipe sticking out of the ground is usually your first clue. And basically what the case said is that if you've got something like that, if you've got a pipe sticking out of the ground or some obvious sign, that is considered to be a patent defect, something that's discoverable by a purchaser during inspection. So you can't go back later and start to allege that there was some latent defect that was failed or that the vendor failed to disclose to the purchaser. You're really going to be stuck if it's something that you should have obviously picked up on during an inspection. So just be aware of that obligation as well. I wanted to talk briefly about the Trident decision, and this is one of my favorite cases. It came out a couple of years ago now, and I'll tell you what it stands for, and I won't go into a lot of detail on the case, but just to give you a flavor for some of the issues that surround cleanup of contaminated land. Trident was a case, and it's Trident and Shell. Shell was a gas station, obviously, in Ottawa, who had caused a significant spill of petroleum hydrocarbons. And the contamination had migrated from the Shell property to an adjacent property owned by a company called Trident Developments. And what happened, and I think this probably hurt Shell significantly at the end of the day when the case went to court, was that Shell cleaned up its own property, but then said to Trident, don't worry, because petroleum hydrocarbons naturally attenuate over time. So with time, it'll go away and it'll dissipate. So don't worry about it. Trident didn't really accept that. And what they said was, we want you to clean up the land. And we don't just want you to clean up the land to the guideline levels. And what I mean by guideline levels is that the Ministry of Environment puts out criteria of what levels of different contaminants are acceptable from their perspective for soil and groundwater. And Trident said, it's not sufficient that you clean up to those levels. We want you to clean up to pristine. We want you to take every molecule of contamination that you put on our property away, because it was clean before, and we shouldn't accept any level of contamination. And then after you do that, we then want you to compensate us for the stigma associated with the property, because if somebody can buy a property that's never had anything on it, or they can buy a property that's being cleaned up, why would they ever take the one that had contamination on it? So you therefore have devalued our property, and we want additional damages for stigma, which I think a lot of environmental lawyers thought was a bit of double dipping. So the case went to trial, and interestingly enough, the trial judge found in favor of Trident. And what they said to them was that when you contaminate someone's property, they said to Shell, you are, and this goes back to the old case Rylance and Fletcher, which we all remember from law school, you've allowed the escape of a contaminant, and you've therefore committed a tort. And there's no reason why that property owner should accept a cleanup to guideline levels. They're just guidelines. They're entitled to have it cleaned to the way it was before. And if it was pristine before, it should be cleaned to pristine. And the trial judge said, I also accept the evidence that someone who's buying a property will prefer a property that's never had contamination on it. So therefore, you also have to pay them damages for stigma. Now, you can imagine this sort of sent the environmental world reeling in terms of what cleanup standards had been and this whole notion of stigma. And the case was appealed to the Ontario Court of Appeal. And what the Ontario Court of Appeal said, they said that the principle of Rylance and Fletcher did apply, that yes, if you contaminate someone's property, you should have to remove everything you put on it. But they said if you did that, there should be no residual stigma damages, because at that point, you've put the property back to the way it was. And why should someone not be interested in the property? In fact, they now have a report which says it's been cleaned up, which may make it even more valuable than a property where you have no idea what the contamination is. So the general rule now is that if you claim against someone for contamination on a common law basis, that you can potentially claim for a cleanup to pristine levels, but you wouldn't be entitled to stigma damages if that was done. Now, environmental lawyers have interpreted that very differently, and there's a huge amount of case law right now and litigation that's out there with respect to that one issue, which is, can you claim for a cleanup to pristine, or are you bound to guideline levels? And I caution you about that issue, and the reason why I bring it to your attention is that it's coming out more and more in agreements. And what I mean by that is you'll see in agreements there'll be clauses regarding remediation and what kind of remediation work is required. And in the past, some of those clauses referred to cleanup guidelines or criteria, or perhaps didn't even set a standard at all. And now there's a lot of debate in terms of what those clauses should say and what type of cleanup should be required under specific circumstances. In the time that I've left, which is probably not a lot, but 2 minutes, I just wanted to mention some points. First of all, I wanted to mention the Limitations Act, and this is from a solicitor's drafting perspective. You should be aware that the limitation period for commencing environmental claims has significantly decreased as a result of the new Limitations Act. And it used to be 6 years, and it's now 2 years. The other interesting point from a drafting perspective that you should be aware of is that previously you could enter into what we call tolling agreements, whereby you would suspend the limitation period from running in respect of contamination that's been discovered. The new Limitations Act, in effect, prohibits those types of agreements. So it really is pushing potential plaintiffs to commence their action within 2 years. And it says that that is despite agreements to the contrary. And I've seen in a lot of agreements provisions that deal with when you can commence your action and how long reps survive and so on and so forth. Be very cautious about those new provisions in the Limitations Act, because they may override and will override your contractual provisions. So I just wanted to caution you on that, because that's a change a lot of people are not aware of. And the other thing that I wanted to say is just to emphasize, and again, I think this sort of leads into Donna's topic about some of the drafting issues, but I wanted to emphasize the importance of how you draft agreements where there are environmental issues. And the reason I say that is because I'm fortunate enough that I do both the litigation side and the solicitor's side of the environmental work. And I can't tell you how many cases I have where we're litigating on the wording used in specific environmental clauses in agreements. Fortunately, none of them were ones that I drafted. But it's a very important issue, and every word is analyzed and has the most important meaning you could ever imagine when it comes to litigation. And, you know, clauses that people standardly put in, like, to the knowledge of, there are no underground storage tanks, or we're providing you with a report, is there an inspection clause, is there not an inspection clause? All of those issues play a huge role when you're before a court and they're looking at what the obligations of the parties are. And so I just caution you to be very careful in drafting, and often I think that's where Donna and I come into play, is that we will be asked to review specifically the environmental provisions and what the impact might be in the event that there was a subsequent problem discovered, what would be the allocation of liability and the rights of the different parties. So I will leave you with that thought about the caution about being careful in drafting, and I think Donna will address some of that later on. Thank you.
When the new Condominium Act came out a number of years ago, I think I basically decided to glaze over and not think about the new concepts of condominiums that were included in the legislation. Stephen Karr practices primarily condominium law. He is a partner at Harris Schaefer, and he is going to take us up to the break and spend about 15 to 20 minutes telling us what these new condominium concepts are that I decided to ignore when they brought out the new legislation. Stephen.
Thank you, Sid. Good morning, everyone. I have the privilege, as Sid said, to bring up the rear of this morning's program and take you into the lunch hour. In the few minutes that I have, I wanted to discuss with you what the impact of the new Condominium Act is for the real estate bar. And it was Sid, actually, who had made the suggestion that we speak about the 4 new concepts that the Condominium Act now has introduced, because I think he was interested in that and he wanted to learn about that. And a clue was when I asked him if I should talk about pottles and condominium law, and he asked me if that was a Harris Schaefer term or if that was a legal term, and he said that. So for you, Sid, I'm doing exactly that. The Condominium Act was proclaimed back in May of 2001 and implemented a whole slew of changes. Many of them were much needed amendments to the old legislation, many of them dealing with consumer protection measures, and some of them dealing with operational measures. But perhaps the most significant changes to the Act relates to the introduction of the 4 new types of condominiums: the common elements condominium, the leasehold condominiums, vacant land condominiums, and phase condominiums. And what I want to do this morning in the time allotted to me is to briefly review the statutory provisions that relate to each of these concepts and walk you through them in order to give you a flavor of each of them. I may spend a few more moments on common elements condominiums simply because there's more of them out there. One of the most popular and successful of the new concepts, quite obviously, is the common element condominium. Prior to the new Condominium Act coming in, many of you may have dealt with freehold homes that were accessed by a private shared road, and that usually required complex easements and very detailed reference plans and complicated legal descriptions, all in order to give legal access for a home to go over a private laneway. The difficulty that this type of mechanism had, and still has for these existing parcels, which are all throughout the GTA, is the fact that there's no obligation, or no mechanism rather, to obligate and enforce the shared responsibility to maintain and repair that road. The strength of the ability for you to maintain and repair the road, or to clear that snow, the snow from the road, is as good as the knock on the door of your neighbor saying, please pay up your share. Well, the Condo Act fixed that by implementing the common elements condominium. It's not a brilliant concept. It's existed in the States for decades. But most simply stated, a common elements condominium is one where the corporation consists solely of common elements and there are no units. It allows developers, from a marketing perspective, to market freehold homes rather than condominiums that have a shared common element. The owners are the persons who share a common interest, such as a road or a utility system, or even a golf course, and we're going to be seeing that one of those very shortly. These owners who own freehold lots which are specifically intended to use or benefit from the common elements are each allocated in the declaration a proportionate share in the common elements, and in this way the freehold lots are tied to the lands. Now, the regulations of the Act speak about parcels of tied lands, And we're all used to, in the real estate bar or in the legal profession, to these acronyms. And parcels of tied lands are referred to as pottles. Not a very sexy name, but it works and it is descriptive. Now, pottles are typically situated, or always situated, outside the boundaries of a condominium corporation. But they don't have to be located adjacent to it. And that's going to allow a much greater flexibility for developers to create golf course type of resorts on common element condominiums, because the homes or the pottles don't have to be next to the shared facility. All you have to do is be within the same registry division. But for the purposes of my comments this morning, I am going to assume that we're talking about a house or a dwelling that's constructed on a pottle, and we'll be talking about the shared road, just for illustration purposes. The costs associated with operating, maintaining, and repairing the common elements are included in the budget, and every pottle owner is financially responsible and obligated to contribute his or her proportionate share. Certainly, if a pottle owner doesn't do that, the pottle owner can be subject to a common expense lien to be registered against their pottle, their home, in the same manner the standard condominium unit and corporation can do with that. The only requirement, of course, is that the lien be in accordance with the time limitations of the Act. But you don't pay for your shared road, you'll get a lien against your home. The common interest of every pottle owner in the common elements condo cannot be severed from the pottle itself. That means you cannot sell the common interest in the common elements separately. It goes hand in hand, one with the other. In this way, the common elements condominium is privately owned by the owners of the corporation. I want to briefly address a few specific matters of which you should be aware of if you are acting for the purchase or on the purchase of a pottle in a new common elements condominium. There are a number of issues with respect to the Ontario New Home Warranty Program. First of all, I don't know if you're aware, but the Ontario New Home Warranty Program has changed its name to Tarion as of just a week or so ago. And that'll come as a surprise to many of you who still refer to the Ontario New Home Warranty Program as HUDAC. So HUDAC, which was ONWIP, which was a very descriptive name, is now Tarion. I asked a speaker the other day at one of the Law Society programs what Tarion stood for, and she replied, nothing. It was a good name. So that's what it's now called. But in any event, residential dwellings constructed on pottles are covered by the Ontario New Home Warranty Program, and they have the same coverage as freehold homes constructed on a plan of subdivision. But while the common elements of a newly constructed standard condominium are covered by the Ontario New Home Warranty Program and are subject to the performance audit, common element condos are not covered by ONWIP. So that's a very, very important distinction. Other areas for you to be aware of is that deposits are covered up to $40,000 for each pottle, as opposed to the $20,000 limit that applies to a condominium. Interest is not paid on deposits that are paid by your purchaser clients with respect to a pottle. Deposits are not trust monies. Deposits on a pottle are just like deposits on a freehold home. They are not payable to a prescribed trustee or to the vendor's solicitor unless you can negotiate that, but they are payable to the vendor, so be mindful of that. And another thing is, when you've acted for a condominium, a standard condominium unit, you're probably aware of the fact that the closing date is typically referred to as a tentative closing date, with these extensions until you get the confirmed closing date and all these strict limitations. That does not apply to a pottle. A pottle is purchased under a freehold form of agreement of purchase and sale and has the 120-day extension, and the deal's automatically terminated if the vendor can't do it unless the purchaser agrees to extend another 120 days or the parties agree otherwise. So be mindful of those types of situations. Other interesting areas for pottles is that the reserve fund of a common elements condo extends only to the common elements, can't be used to benefit a pottle. So when you're looking at the budget, it's amazing how often our office gets phone calls on the day of closing saying, my client didn't realize that they were buying a condo. A pottle is a hybrid. It is a freehold dwelling with an attached common elements condo. It is very much a condo. The lender should be aware of it. Your legal description should be mindful of it. Your title searchers should be mindful of it. You have to look at these things, and I'll get into a few of the other areas later on. But even though it's a hybrid form of condo, the pottle owner is totally responsible for the maintenance and repair of every aspect of their dwelling. The common elements condo only is responsible for the common elements. With respect to insurance, a master insurance policy for common elements only insures the common elements and not the pottles or the dwellings that are constructed on them. So every pottle has to be separately insured. If you act for developers, one of the important things to be aware of is your timing for going to market. Unlike standard condominium units, which are exempt from compliance with the Planning Act and which permit developers to enter into agreements of purchase and sale before draft plan approval of condominium is obtained, developers don't have that same flexibility with pottles. You have to be draft approved for a plan of subdivision or be on a plan of subdivision. Now, if the project is being created on land that has an underlying plan of subdivision, then you can automatically start marketing your project, no problem. If there is no underlying plan of subdivision, a developer can obtain consents from the local land division committee for each pottle, but as you know, the cost of that is prohibitive and is probably not a very, very wise thing to do if you are, let's say, beyond 6 or 7 homes. It's also possible that the land division committee would look at any application for separate consents as being really not an appropriate mechanism and urge that developer to reapply for a plan of subdivision. If a plan of subdivision is required, a developer can't enter into agreements of purchase and sale until draft plan approval of the subdivision has been obtained. Therefore, if you're acting on a purchase, one of the good questions to ask of the vendor solicitor is, are they draft plan approved? You want to make sure that you are on side in that regard. I want to walk you through some of the steps for registration because many of you come across deals where the house is built because it's a freehold style house and they can do the freehold style mechanism, but the application process is much more convoluted, much more involved, and therefore delays the actual conveyance. Registering a condominium for a common elements condominium requires various applications to be submitted by the developer for a draft plan, a subdivision, or the consents, as I mentioned. The developer has to submit an application for site plan approval, or if necessary, a part lot control exemption bylaw, and also has to submit an application for condominium, for a common elements condominium. Some of these applications are submitted on a parallel basis, or some of them can be staggered depending on what the specific requirements of the developer are. But once you get all those applications in and construction has been completed to permit registration, there's a whole slew of other aspects that have to be completed. The registration of the plan of subdivision has to be undertaken and completed if that's required. The deposit and pre-approval and deposit of a reference plan, if necessary, setting out the individual pottles and the parts on the plan. The registration of a part lot control exemption bylaw. Don't forget, it's not enough to get the bylaw, it has to be registered, as one of my clients found out. The approval authority has now caught on. Now, we sort of encouraged it, and you see it everywhere, but the approval authority, the local municipality, will register a no dealings under Section 118. And the reason they do that is they want to make sure that a developer doesn't walk away from their condominium development lawyer, go to another lawyer and say, hey, let me start selling off the houses without the condominium plan being registered, because there would be no legal access. So one way to prevent any conveyances is to register no dealings. Once that's done, you'll typically see a declarant registering a deed from itself to itself in order to create the individual pottles and the PIN numbers. And you need those PIN numbers so that we can insert those PIN numbers into our Schedule D, setting out our percentages in our declaration. And once we have that, we can then submit our declaration for pre-approval. So you can see how all this process ties one to the other. You're really threading things, and if there's a backup or backlog at the registry office, you could be waiting many, many weeks or months. Once your declaration is pre-approved, you submit it for registration with the common elements condominium plan. You got to make sure, of course, all the requirements for the approval authority conditions have been met. And the last but not least, the approval authority usually has no difficulty, but they will release their Section 118 so that you can start sales. start the conveyances. Now, this process can be very, very time-consuming, very, very cumbersome and expensive. There's delays in construction and delays in registering. There's delays in purchasers' mortgagees figuring out what it is that their client is buying. There's delays in the title insurers figuring out what the client is buying. There's delays on the purchaser's side sometimes in recognizing that they bought a condominium as well. There's still a lot of room for streamlining, and we'll be seeing that in the future. But I think common elements are certainly a mainstay here. Leasehold condominiums are a different breed. They offer the possibility of expanding the condominium concept to institutional lands such as religious organizations, universities, hospitals, and other institutions that have excess or surplus lands. And very often these types of institutional landowners can grant developers these long-term interests in its surplus lands, which it might otherwise be unable to convey for legal purposes, or which it may want to retain for long-term development purposes 50, 75, or 100 years from now. Leasehold condos are also seen as a means of encouraging the construction and supply of affordable housing, as the land value, which is leasehold rather than freehold, would presumably be lower and could be reflected in the purchase price. The concept of leasehold condo is therefore intended to encourage the development of these lands and to provide revenues to these institutions which might otherwise be sitting with dormant land. The Condo Act wants to make sure that leasehold condominiums are treated with the same manner as a standard condominium, so they said that everything that applies to a standard, for all intents and purposes, applies to leasehold. We'll just change the name from standard unit to leasehold unit. Now, leasehold condos are similar to standard condos, with the most fundamental exception being that leasehold condos are registered upon leasehold rather than freehold land. And a declarant can register a declaration that divides the leasehold estate into units and common elements, but the first thing that they have to do is make sure that they have the leasehold in place, and typically the way you do that is by registering an underlying ground lease having a term of not less than 40 years and not more than 99 years. Now, the method to the madness on that for establishing this goalpost of 40 to 99 is presumably established to reflect the realistic lifespan of a building, as well as to ensure the marketability of leasehold units. Any shorter term really wouldn't encourage developers to get into the game and to construct a multi-million-dollar building on the lands. Also, you want to make sure that it can accommodate the mortgaging and marketing ability so that buyers of a leasehold condominium would be interested in buying one of these units. Title to a unit is just like a title to a standard unit. It can be conveyed, mortgaged, without having to go to the underlying lessor, ensuring that way that leasehold units can be sold just the way standard condominium units can be sold. What's interesting is that the Tenant Protection Act does not apply to the leasehold condominium. Now, if you are a leasehold unit owner and you lease out your leasehold unit, the Tenant Protection Act does apply to the lease of the suite, certainly, but it does not apply to the owner of the freehold estate and the owner of the leasehold estate. Now, many of the provisions concerning what can be contained in a declaration are similar to those found in a standard freehold condominium. Very briefly, it must contain a statement of the term of the leasehold interest of the owners, and these are things that you should be looking for if you are being asked to review documents. A schedule setting out the amount of rent payable by the condominium corporation for at least the first 5 years following registration, as well as a formula to determine the amount of rent payable for the remainder of the term. It also has to include a schedule of all provisions that are going to affect the condominium that are set out in the underlying lease. It's not enough to have a registered lease and then to refer to it by reference to an instrument number in your declaration. If it ain't in the lease, it's not enforceable against the leasehold condominium. So if you're acting for a leasehold developer, make sure that all the provisions that you want to have in that underlying ground lease are included in the declaration. I'm seeing time, so I want to quickly go on. The rent that is payable to a lessor forms part of the common expenses of the leasehold condominium, and every owner is obligated to contribute to that. If they don't pay it, just like in any other condominium, the leasehold unit will be subject to a common expense lien. Now, because there's a time limit on leaseholds, the underlying landlord must advise the condominium corporation in writing at least 5 years before the end of the term of the leasehold condominium of its intention to either renew or not to renew the leasehold interest. a renewal of the leasehold interest has to be for at least 10 years or a longer term, as set out in the notice, unless 80% of them vote against it. I just want to make sure that I cover a few more things. Phased condominiums. Prior to the new Condominium Act coming in, phased condominiums were developed by registering individual buildings or townhouse complexes and engaging in complex reciprocal agreements to govern the use and operation of the cost sharing and the integrated relationship between the corporations. The beauty of that is that a developer could construct units in a condominium corporation to the extent that they could market them, and you had less risk exposed both to the developer and to the construction lender. But the difficulty was you also had duplication of costs. So there's multiple applications to the approval authorities, multiple loan facilities, multiple registrations and all the rest, and the budgets duplicated costs as well. The phased condominium takes the concept of phasing one step further by allowing the various phases of a condo development to be registered under one condominium corporation. So although a condominium development starts as a single standard condominium, once that first condo is registered, the second phase can be registered through an amendment to the declaration and description, and that phase is added to the first condominium. So therefore, instead of registering multiple condominiums, you have one condominium corporation with one declaration, one set of bylaws, one set of rules, and the beauty of it is that you don't need any complex reciprocal agreements to govern access or servicing agreements and complex reference plans to deal with that. The difficulty that you have with phased condominiums and why we may not be seeing a lot of them is that there is a very, very great degree of disclosure that a developer has to provide for the subsequent phases. And that's a test that many developers may not be able to meet. For example, a disclosure statement for the sale of a unit in a phased condo has to contain various statements whether the declarant intends to do additional phases, but at the same time warning them that we may never go ahead and do these phases. It's a little weasel language in the Condo Act, but it's there. The disclosure statement must also indicate the projected year of registration of the amendments to the declaration. And in addition, the disclosure statement has to set out the approximate number of units in each phase, the legal description of each phase, the approximate location of buildings and structures within each phase, a description of the facilities and services to be contained in each phase, a statement of the percentages, what they're going to be after the amendments are registered, so what it's going to be, a statement of the facilities and services that the owners will share after the creation of each phase. So to satisfy this, you need all that detailed information up front, years before you're even contemplating much of what's going to be happening. And that level of detail and specificity effectively destroys the very flexibility that a developer needs to be able to adjust to market requirements. Any change to a subsequent phase might open up the 10-day rescission period, and that would be fairly detrimental to a developer. So it's likely we'll only be seeing these types of phased condos where we have a site-specific site plan that's incapable of being revised, and the site is small enough that all phases be constructed and registered within the limitations set out in the Act. In the final 2 minutes that I have, I'm going to touch upon vacant lands. We're not too late for lunch. In a vacant land condominium corporation, this is an exciting area, actually, vacant lands. We're doing a couple of these. Where's Robin with the tax and the coma stuff? And there's something sad when vacant land condos are exciting. But what's interesting is that no structures are required to be built for the units at the time of registration. The units are the vacant lots. And the declaration for a vacant land condo corp will set out standards covering the size, the location, the construction, the design, the appearance of the structure that's going to be constructed on, architectural and construction design, minimum maintenance requirements. They want to know all the sort of things that will govern the appearance of the building that will be built on the unit lots. And these restrictions, which are found in a declaration, are intended to allow the declarant or the board of directors, after it's registered, to exercise control over the size, the type, design of the houses that are going to be built within the vacant land condo in order to ensure architectural control with what's being built, similar to a building scheme that you're going to find. But unlike building schemes which expire after 20 years or so, these go in perpetuity because they're registered in the declaration. The description, the condominium plan of a vacant land condo corp has to contain a plan of survey showing the perimeter of the land and any structures to be built on the common elements. Similar to a common element condominium corporation, the municipality will provide a statement of owners, or the purchasers, respecting the extent to which municipal services will or will not be available to the property, including the construction and maintenance of roads, and whether the municipality will require a bond or other security to be given to ensure the completion of these structures or facilities. In a vacant land condominium, unit owners are required to maintain their own unit, including any housing structure built on it, and to repair it. Obviously, they have to do that at their own bill. They also have to obtain their own insurance, and if the building is damaged, the owner repairs it and restores the land. Lastly, an agreement of purchase and sale for a vacant land condo entered into prior to the issuance of draft plan approval is voidable at the option of the purchaser. This is the only type of condominium unit that this applies to, so that's something you should be aware of. The sale of all other forms of condo units is exempt. To conclude on vacant land, it provides an excellent opportunity to achieve many of the goals and objectives supporting the introduction of new condominium concepts. But the Ministry of Consumer and Business Services has very recently taken a very strict interpretation of the Act that a structure on a vacant land unit can't cross the boundary of a unit. And effectively what that means, it limits vacant lands to single-family homes. In that instance, it cannot be utilized for townhomes which would be built across unit boundaries. So unless there's some sort of amendment, you're going to see vacant land condos being utilized primarily for single-family homes and rather than townhomes or semi-detached. The end of the paper talks about a very interesting thing. I'll leave that for you to read later on, but it's the nesting of condominiums within condominiums. It's establishing a common elements condominium with poddles and shared roads, and a particular poddle can then be bought by a developer. Obviously, it would be several acres or hectares, and then have another condominium, a standard condominium, built on top of that. So we're nesting condos within condos, and this is going to create a much greater diversity and flexibility for developers and for purchasers in the future. Thank you very much, and enjoy the rest of the program.
Thank you. We'll resume again at 1:45. Remember the question box, and we'll see you in a bit. Thank you.